Coming to section 32, subsection 1, dying declaration. It runs when the statement is made by a person as to the cause of his death or as to any of the circumstances of the transaction which resulted in his death, in a case in which the cause of that person's death comes into question. Such statements are relevant whether the person who made them was or was not at the time when they were made under expectation of a death, and whatever may be the nature of the proceeding in which the cause of his death comes into question. Section 32 is pretty long one. It provides as exception to the rule of exclusion of hearsay evidence. It is based upon the principle that the person who has first hand upon knowledge of the fact of the case, but who, for the person mentioned in the section, unable to attend the court, then his knowledge should be transmitted to the court through another person. The law wants the best evidence in all cases. Under section 33, relevancy of the previous evidence. Evidence given by a witness in a judicial proceeding or before any person authorized by the law to take it is relevant for the purpose of proving in a subsequent judicial proceeding or in a later stage of the same judicial proceeding the truth of the fact which it states when the witness is dead or cannot be found, or is incapable of giving evidence, or is kept out of the way by the adverse party, or if his presence cannot be obtained without an amount of delay or expense which, under the circumstances of the case, the court considers unreasonably, provided that the proceeding was between the same parties or their representative in interest, that the adverse party in the first proceeding had the right and opportunity to cross-examine, that the question in issue were substantially the same in the first and the second proceedings. Explanation: a criminal trial or inquiry shall be deemed to be proceeding between the prosecutor and the accused within the meaning of this section. Evidence in one case cannot be considered in another case. Section 33, which is an exception to this rule, is applicable to the cases in which evidence given by the witnesses. Number 1, in a judicial proceeding, or number 2, before any person who is authorized by law to take evidence, and number 3, the witness cannot be called to give evidence before the same court at the latter stage, before the same or another court in a subsequent case. Now coming to the judicial proceeding, the principle is applicable in a judicial proceeding and before any person authorized by law. Judicial proceeding means any proceeding where evidence is taken on oath. Evidence given by witness in a judicial proceeding is relevant for the purpose of proving a particular fact in a later stage of the same judicial proceeding, when a witness cannot be found or is dead. Now, case laws pertaining to this: the Purushottam Chopra and another versus State, Criminal Appeal number 194 to 195 of 2012, Supreme Court. The Supreme Court observed that merely because the deceased had suffered 100% burn injuries, it cannot be said that he or she was incapable to make a statement which could be acted upon as a dying declaration. The contention taken in this case was that the victim had suffered 100% burns and he was already in a critical condition, and further to that, his condition was regularly deteriorating. It was contended that in such a critical and deteriorating condition, he could not have made proper, coherent, and intelligible statement. The accused in this case were held guilty of causing death of Sesing by putting him on a fire. Another case, Punambai versus State of Chhattisgarh, Criminal Appeal Number 903 of 2018. In the year 2018, the Honorable Supreme Court acquitted a convict by setting aside a judgment of the High Court of Chhattisgarh, which had convicted her for a murder after finding lacuna in the dying declaration. In a case, the person recording the dying declaration is satisfied that the declarant is in a fit medical condition to make the statement, and if there are no suspicious circumstances, the dying declaration may not be invalid solely on the ground that it was not certified by the doctor is only a rule of prudence to be applied based on the facts and circumstances of the case. The real test is as to whether the dying declaration is truthful and voluntary. Under section 34 to 39, the statement made under special circumstances. Section 34, entries in a books of account when relevant. Entries in a books of account, including those maintained in an electronic form, regularly kept in the course of business, are relevant whenever they refer to a matter into which the court has to inquire, but such statement shall not alone be sufficient evidence to charge any person with liability. Section 35, relevancy of an entry in a public record made in performance of a duty. An entry in a public or other official book, register, or record or electronic record stating the fact in issue or relevant fact and made by a public servant in the discharge of his official duty or by any other person in performance of a duty specifically enjoined by the law of the country in which such book, register, or record or an electronic record is kept is itself a relevant fact. Section 36 deals with relevancy of a statement in a maps, charts, or a plans. Statement of a fact in issue or relevant fact made in a published map or a chart generally offered for a public sale, or in a maps or a plans made under the authority of the central government or any state government as to the matter usually represented or stated in such maps, charts, plans are themselves relevant facts. Section 37 deals with relevancy of a statement as to a fact of public nature contained in a certain acts or notification. When the court has to form an opinion as to the existence of any fact of a public nature, any statement of it made in a recital contained in any act of Parliament of the United Kingdom or any central act, provincial act, or a state act, or in a government notification or notification by the Crown representatives appearing in the official gazette or in any printed paper purporting to be a London Gazette or the government gazette of any dominion, colony, or a possession of His Majesty is the relevant fact. Section 37 deals with relevancy of a statement as to any law contained in any law books. When the court has to form an opinion as to law of any country, any statement of such law contained in any book purporting to be printed or published under the authority of the government of such country and to contain any such law and any report of ruling of the court of such country contained in a book purporting to be report of such ruling is relevant. Section 39 deals with what evidence to be given when a statement form part of conversation, documents, electronic record, book, or a service of letters or a papers. When any statement of which evidence is given in the form part of a longer statement or of a conversation or a part of an isolated document or is contained in a document which forms a part of a book or is contained in any part of electronic record or connected series of letters or papers, evidence shall be given of so much and no more of a written statement, conversation, documents, electronic record, book, or a series of letters or a papers as the court consider necessary in that particular case to the full understanding of the nature and the effect of statement and of the circumstances under which it was made.